Okay, we're here with Kate Bihm, and she's running for the Judicial Court number 9. I'm John Wirtz, Voting Committee Chair, Montgomery County Tea Party. With me is Pat Tibbs, and Brian Crumby, and Del Fessington, and Ken Vaughn, and Larry Rogers. And so what we'll do is start off with your opening of 5 minutes, and then we'll go around the table for Q&A. And also, let me mention that you have up to 2 minutes to answer each question.
Okay, good to know.
All right.
Yes.
Good deal.
I'll start my 5 minutes by telling you guys a little bit about me and my history that you may not know. I'm originally from Bryan, Texas, and my parents are Nolan and Doy Shipman. My father's a physician. My mom has worked as his practice manager and also as a small business owner. My parents are both entrepreneurs, and I was very fortunate to be raised in a Christian household. My parents were very conservative and also very involved in local politics, and of course all politics is local, and encouraged me to get involved as well. I consider myself to be very privileged to have been raised by two good people with good heads on their shoulders who encouraged me to be a good citizen. I attended Bryan High School and then went on to Texas A&M University, where I got a Bachelor of Arts in Sociology with an emphasis in deviant behavior. And a lot of people think of sociology as being kind of a precursor to social work. My studies were more involved in social theory and deviant behavior, and relates not so much to what we might think of as deviant from a layperson's terms, but more people who choose to live against the norm. So a lot of what I studied was aggression theories, and I found that to be really fascinating. And then I went on to law school at Texas Tech University. While at Texas Tech, I was a member of the Phi Delta Phi Honor Society. I was on the Dean's List, on Board of Barristers, and was also on the National Moot Court team. So I was honored to get to fly around the United States and represent my school in that regard. After law school, I went to work at a insurance defense boutique in Amarillo, where I was completely miserable. And shortly thereafter, after about 6 months of living in Amarillo, I moved here to Montgomery County, where I worked for Mike McDougall as an assistant district attorney. And after doing that for about 3 years, I opened my own practice and have been in private solo practice since then. As you've read from my questionnaire, and if you've looked at my website and my campaign website and all of those things, you know a little bit more about my accomplishments while I've been in private practice. I decided to run for the 9th District Court, as you know from my questionnaire, because I believe that that court needed a change, and I believed that the people of Montgomery County deserved a candidate who had a different type of experience than the other people that were known to be in the race at the time. I love Montgomery County. I sound so cheesy when I say that, but when I moved here, I was, I guess, 25 years old, 26 years old, I think, right after I turned 26 years old. And I was unmarried. I knew not a single soul. The only thing I knew about the area was that there was a pretty decent Mexican food restaurant on 105, and that it was 70 miles from where my family lived. I mean, I knew nobody. And this community took me in. People, said, come to church with us. Come get involved. Come join Lions Club. Come join the Rotary Club. Come. We would love to have you. And I've just really loved living here. And I've been very honored by the fact that the people of Montgomery County in this area have made it possible for me to feed my family. They've made it possible for me to purchase a home and to excel and succeed. And I think that that's just really a neat thing that I cherish. And I know that there are a lot of places where that sense of community doesn't exist. And one of the things that I think is really neat about Montgomery County is that this is a place where, when people say, where are you from? There are some places where they might say, oh, I'm from Longview, or I'm from Bryan College Station. I would never say I'm from Brazos County. But you do hear people say, I'm from Montgomery County. And that's kind of part of our identity of what we have here, and I think it's a really neat thing. And I'm really committed to the people of this county, and I love that we are a conservative people, and we're a compassionate people. And by and large, we're a really well-educated populace. And I want to represent who we are as a people on the bench. And I believe that I have the legal knowledge to do that. I have the love of our community to really consider who we are, what we want, and what's right for our county in making decisions. And that's one of the reasons why I believe I'm the right person for the job.
Perfect. Perfect timing. Okay, so at this juncture, we'll go around the table, and I'll start off.
Okay.
What separates you from your opponent?
The biggest separation between us is the type of experience that we have. My opponent has been a prosecutor his entire career, and I think that it's something that you need to consider. If you've done one thing for 20 years, on March 2nd, are you going to wake up and suddenly be something different? And, you know, is it reasonable to expect someone to suddenly be able to see all sides? So I've been both a prosecutor and a defense lawyer. If you talk to anybody who knew me or had to try a case against me when I was a prosecutor, I was just as rabid as a prosecutor as I am as a defense lawyer, because that's what lawyers do. We're advocates. And that's a big difference between what a judge does. And I think that's an important point. I think that my opponent has made it clear in some of the things that he has said and done while he's been out campaigning that he does have a very close relationship with some elected officials. And I'm very independently minded. As a solo practitioner, I went out on my own and acted as a solo practitioner because I wanted to be able to make my own decisions based upon what I thought was right for my clients. And I think that's what judges have to do too, is be independent thinkers based upon the law and what's right. I think the other thing that's different between the two of us is that I've received a lot of recognition from my peers and from my clients for the work that I've done. I'm an award-winning lawyer, and I've been highly successful in my field. Probably the greatest difference between us is the type of experience we've had in the last few years. Since he's been in Montgomery County, my opponent's been primarily an administrator. For the last 11 years, my practice has been entirely in the courtroom, both at the trial and appellate level.
So, but, I mean, how much of it has been court and how much has that been?
Total. Well,
That's fine.
We'll pass me and go to you, and then I'll come back to me.
I wasn't trying to make that a full question, I didn't know how much time was left, I just kind of wanted, I mean, so when you say you're in court, I mean, a lot of, what percentage is in the court, how much of it is in negotiations?
Most of the negotiating in criminal courts happens in the courtroom. So I would say that I'm in court on average 3 to 5 days a week.
Okay.
That was small.
I mean, I can
Quick.
talk more
That's
about
what
like
I
what
said.
my average day in court is like, but 3 to 5 days a week.
I was particularly interested in the question, among the 9 justices of the Supreme Court, which one do you favor the most, and why, and which one do you respect the least, and why? Could you reiterate that?
Sure. I've always been a fan of Antonin Scalia. I think it's interesting, I should point out that both of the justices that I pointed out, Ruth Bader Ginsburg and Antonin Scalia, they're known to be very close friends, which I think is just fascinating because their approach to the law is so different. Antonin Scalia is an originalist, and I like that sometimes in his opinions you can almost read how much he hates what his answer is, that he's disappointed by it. One of the cases that I cited in my answers, which is Troxel versus Grenville, Antonin Scalia actually wrote a scathing dissent in that case. His argument being that there is no constitutional right to what Troxel versus Grenville said, and how disappointed we are that there's no constitutional right to it, but because it's left out of the Constitution, it must be left up to the states. And then Ruth Bader Ginsburg, on the other hand, who I think is, a highly intelligent person, etc., she's very results oriented. And I think that she makes decisions and writes opinions based upon what she thinks the outcome ought to be, based upon social engineering and other ideas, then it really has a whole lot to do with the law. I mean, I think we saw that in the Obergefell decision, that a lot of people were very disappointed in that it was like, this has nothing to do with really any legal precedent. This is just what you want the answer to be. And I think that that's how a lot of her opinions are written, and that's always very disappointing to me.
So our job here is, we have to figure out the candidates and,
Right.
So sometimes I can come across as being very scrutinizing, so don't worry about that.
It's expected.
So your answer about licensing, where you said that a barber doesn't need to be licensed by the state, but a lawyer does. I can argue both sides of that. I guess I would ask, maybe I'd ask a different way. What does government do that's more efficient than the private sector? Your list of things, what would your list of things that the government does more efficiently or better?
More efficiently than the private sector, or is better equipped to do? Because I think that those are two different
equate
things.
those two.
Okay. I think of efficiency as being a kind of a cost-benefits situation, and equipped being who, in some ways not necessarily equipped, but who the people are more likely to accept the authority from.
Oh, well, okay.
Do you understand what I'm saying? Like, I think if we
Okay.
just turn the military over to Blackwater, the American populace, even though they might be more efficient at it, would be very upset about it. So I think that our government is ideally suited for law enforcement. I think they're ideally suited for our military.
So the question, my question is not what do people expect? And I understand your comment about abrupt change can be abrupt. You can,
Right.
that's a 180 and people would freak out. But I guess more question is, where should it go? Which direction? Should it stay there? It's really an efficiency question. Is what in your list of government roles is more efficient in the private sector? And it may be none.
Is more efficient in the private, like what should we turn over to the private sector, or what should the government, do you understand, like what is the government doing now that should be private sector, or what should the government, what I think the government's role is? Because those are two different things, because I don't think that the government should be licensing barbers. I think I'm probably better equipped to determine who should cut my hair than the government.
Okay.
But
And why
they
is
do.
the government better at choosing who should be a lawyer and not you a private individual?
That's a good question. I'm almost out of time. May I request
I
more
can
time?
come back and we can do a round two.
Okay, can we do a round two? Because I got kind of wrapped up in my head, so
That's
I
fine.
apologize
No,
for
that's
that.
fine, that's fine.
Okay.
Nullification.
Mhm.
Tell me what you think about it. What are the pros? What are the cons? What experience have you had in that regard? Either prosecutor, defense attorney, whatever. Just talk about that topic for a little bit for us.
Okay. I think that jury nullification is a right of the people, first and foremost. There are cases that hold that a defense lawyer is not permitted to stand up and argue that a jury should nullify. We are limited to arguing that a juror should vote their conscience, and if that's guilty versus, in that regard. I have certainly had cases in which I felt that jury nullification would be appropriate, and I do think that jury nullification happens every day, I might add. I don't necessarily think it happens at the trial level. I think where jury nullification often happens is at the grand jury level, where we will present a case to a grand jury, and I'll give you an example of something that happened in my own practice. That was, the names are changed and the facts to, protect the innocent. But where you might have a 17-year-old young man who is literally caught red-handed in sexual congress with a 14-year-old young woman. He's a legal adult. they don't meet the statutory requirements of the Romeo and Juliet law, but it's a consensual relationship. I think that there are a lot of people who would argue that as a society, it would be inappropriate to subject that young man to 5 to 99 years in prison due to the consensual nature of their relationship, the relative maturity of the child, and the like. So oftentimes cases where that's appropriate are submitted to a grand jury, and the grand jury will decide not to indict, even though there may be sufficient evidence to proceed. And so I do think that jury nullification does happen more often than I think the public probably realizes, just not at the level at which they do. But I believe that it's an appropriate and important right of the people and of the jury, but we are limited by prior precedent and other courts have held as to what types of argument can be made in its favor.
Okay. Okay.
Does that answer your question fully?
Questions are never answered
So
fully, but
right? We could
satisfactorily.
talk about this all day.
Sure, surely we can.
But if you have
But no, that was, I enjoyed hearing what you had to say.
okay.
Ken?
All right, what's the budget for the court?
I don't know what the exact budget is for the court.
Okay. So you don't have an idea of where that might need to be modified at all?
Changed?
Yeah.
Well, I think one place it needs to be modified, and I think that this is generally speaking, is that court has had a number of jury panels that have been what we call in our parlance busted, okay? Where you've called dozens and dozens of people down there, only 4 hours later for them to be released because a decision has been made that there's an insufficient number of jurors to go forward, okay? After jury selection. And I don't think that that's necessarily a good use of the court's time and money or the people's time and money. Sometimes it's unavoidable, I would add. I think that all courts should minimize the days that visiting judges are appropriate, the days that visiting judges are on the bench. I think that's one area that any court should say, how can we maximize our schedule, just like you and I maximize our vacation time, to say, well, I'm going to make sure that I schedule my vacation around when a judge needs to be on the bench and when a judge is not essential, when we've got other judges that are already on the bench in Montgomery County that are willing to help out, who would fill in that type of thing. So I think that that's something as well.
So just to follow on to that, since we have a little time left, when the visiting judge comes in, is he getting or is she getting their salary from where they're coming from, as opposed to we're also supplementing that salary and from Montgomery County
No.
coffers?
That's a good question. Visiting judges are paid on a day rate. They're typically retired judges or judges who have not been reelected, okay? That then if they forego private practice entirely, that they are paid a day rate by the county.
Okay, all right.
Okay, and the question here on number 4, one of your answers was basically, I would encourage the vetting committee to determine whether candidates are following the rules required of judicial candidates. Could you elaborate on that a little bit and explain your reasoning behind that, or
Sure.
why you brought that up?
Judicial candidates are required to follow the same rules that district and county judges follow. We are supposed to be treated as though we are already on the bench as far as what we can say, what we can do, and the like. And you guys really have no way of knowing whether
Right.
we would follow the law.
So,
And so what I would suggest that you do is to look at the rules that we're supposed to be following right now.
Can you give us the basics?
I would say that one thing that we're prohibited from doing is for campaigning for other candidates or for otherwise standing up and saying that we specifically support another candidate. We are prohibited from having campaign events or otherwise appearing to endorse any other candidates. There's not actually that many judicial ethics opinions, by the way. When I got into all of this, I thought, I better look at what rules I'm supposed to be following. And there's really only a couple of hundred of them, which is surprising. But we're limited as far as what we can say and what we can do. And I think that that's really important. One thing that we're prohibited from doing is we're prohibited from remarking upon a sitting judge's opinions or decisions in such a way that it casts light on what we would do in a similar case. And so one of the things that we have to be really careful about doing is criticizing a sitting judge's opinion, even if we completely disagree with it. We really can't come forward and say, this is horrible. You know, at least that's the way that I read the rules to be. And so I think you have to look at what we're supposed to be doing and say, okay, is this a person who's following the rules now? Because if they're following the rules now, we can expect them to follow the rules
Do you
in
have
the
any
future.
instances that you'd like to bring to the surface?
Not at this time, no. I don't think it's my role to do that.
But even in a campaign, you think that's off limits? You don't criticize the sitting judge? Excuse me.
You can certainly criticize a sitting judge. I think that's a good question. You can criticize the sitting judge, but you can't criticize specific opinions to the extent that it casts light on whether you would rule differently under those circumstances. And there's a judicial ethics opinion that is directly on point as to that.
Mhm.
And so I think that that's one of the things that we have to be really careful about. That's the hardest thing about running for judge, is you can't just sit up and say,
So is that if you vote for me, I won't put Johnny in jail? Is that what is behind that?
it's that, and I think part of the issue with it really is that you don't want to put yourself in a position where if someone comes before your court, that the parties have a reasonable expectation of what you're going to do. It has more to do with the appearance of fairness and impartiality. That you can't stand up and say,
Okay.
in cases involving X, I will do Y. And that's because we don't know the facts. We don't know, exactly what we would do, even if we might have some good idea, a general idea. And it's hard, by the way, it's really hard not to say, especially, if you've been, politically active and have a very clear vision of, what you think is right, to sometimes just say, I would never, or I would always. We can't say. We have to keep an open mind and hear all the facts.
Okay. In question number 9, what are the top 3 areas where the budget for this office needs to be adjusted? Ken touched on that somewhat. And about the 4th or 5th line, you said there's no reason to pay people or make them miss work if all matters can be resolved without a jury in advance. And I understand there appears to be a concern that the current judge is not taking advantage of all that and maybe on the borderline of maybe abusing the time available to him to process cases to get through. Okay, so what percent of cases or time does it occur that we're paying people and making them miss work where these matters can be resolved without a jury in advance? In other words, how much can we save?
How much can we save?
Yeah.
It's impossible to tell. And part of the reason why it's impossible to tell is because there's some kind of magic that happens in a courtroom. And I know that sounds so silly, but sometimes you will have a defendant who wants his day in court, 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 and then when he actually sees the jury panel, looks over at his lawyer and says, I want the 20. Can we still do the plea bargain? And quite frankly, if you have to look at, well, we can either pay these people $15 for today and let the person go to prison or accept the plea bargain, or we can possibly pay these people $15 today and then $40 every day they after, and then, just you gotta pay the light bill in the courthouse, right? So that's one of the issues that you really have to look at, is that when someone is willing to go to prison, or when someone is willing to accept punishment, it is often almost always the most efficient outcome in the case. And part of the reason for that is because when someone agrees to plead guilty, they also waive the right of appeal. So we save money at almost all levels of the judicial system there. So that can be very valuable. And so I think that it's one of those things that I'm very, very rarely going to stand in the way of somebody sending themselves to the penitentiary.
So how much do prosecuting attorneys abuse that intimidation factor? And Matt, I mean, here you've got this uninformed, civilian charged with something. They don't understand the system. This experienced attorney knows how to press. How much of the time is that knowledge, experience abused?
I can't give
If
you a
it's-
percentage. I'll tell you it happens a lot.
Yeah, okay.
It happens a lot. I think one of the things that's really frustrating when you work on the defense side is when you have a situation where you know that the prosecutor knows how what we say is how much a case is worth, what it's worth. And where you can also see that they're deliberately playing upon the defendant's fear in order to increase a number or in order to otherwise obtain another objective. And for me, that's, on the defense side, it's repugnant. That justice is justice. I heard my opponent say on another forum, some people deserve just a little bit more justice. No. Justice is an ideal. It's not something to be meted out and wielded like a hammer. That's what the courts are there to do, is to pursue an ideal. And I think that that's really critical. And that's something that I personally am very passionate about. And that I think that, you read that part of my judicial philosophy is personal responsibility, accountability, and a smaller, more efficient government. And when the parties come together and know that both sides will be treated fairly, I think that justice really can happen. But when people walk into court and feel as though the deck is stacked against them from the very beginning, on all sides, they're willing to do just almost anything just to try to get down the road. And that's unfortunate. That's unfortunate to me. But I think that at the same time, I deal with fair prosecutors who treat my clients fairly all the time. One of the things that led me into defense work was dealing with defense lawyers that I would look at and just say, just do the work for your client. Just do the work. So there's bad actors on both sides, and part of what judges have to do is to make sure that the playing field is appropriate for the parties, I think. Not to step in, but to really, I use this baseball analogy, to call balls and strikes.
So let me elaborate, and I'll use my question up.
I thought you already did.
Well,
Sorry.
I may have, but on that same vein, is the defense lawyer, is their job to get their guy off, or is their job for justice to be served?
No.
And what do lawyers think?
No. And there's a really beautifully written judicial opinion on this subject that I can't remember who the author of the opinion is that the defense lawyer's job is the zealous defense of their client, and to make sure that they take advantage of every protection that's afforded under the United States Constitution in order to make sure that their client is treated fairly. The prosecutor's sworn job is to do justice. And like I said before, I believe that justice is an ideal. It's not a hammer.
Okay.
For the last several sessions, we have tried to urge our lawmakers to make a law stating that American laws are American courts. What happens if a case comes in front of you and both attorneys want to use Sharia law? What can you as an attorney, as the judge do?
Well, it doesn't apply. The parties can't agree as to what law governs the court. Texas judges are sworn to uphold the Texas Constitution, the United States Constitution, and the laws of our state, not any other laws.
but there is a court in Richardson, Texas.
Yes, and that's a good question, but that court is not a district court or a county court that's a sworn Texas justice. Now, if the parties decide to settle their dispute using, to me, I think of that as more like arbitration. If two parties decide to go to a third party and have their dispute upheld by that third party, then that's their choice in how they settle their dispute. But if a person files a lawsuit in Montgomery County and says Sharia law applies, they're going to get laughed out of court. Because it quite simply doesn't.
I hope you're right.
I think now, I will say, just because I have a little bit of time left, I will say that, and I'm going to get really kind of dorky about, I'm going to get really lawyerly and dorky about this. I do think that there's a circumstance where parties can agree to could make a contract to agree to have Sharia law govern their contract. But whether that's conscionable would be a question for the court. And so if it was something that was unconscionable or that was contrary to the laws of the state of Texas, then Texas law says that that provision is stricken. Unenforceable, yes.
Okay, I'm going to try to draw a number of things together. Forgive me if I'm a little bit awkward in this, but I'm going to try. Question number 2, you're talking about one of your primary goals, reducing the backlog of cases. I've heard that that's quite an issue, and then tying into that, one of the things that I've seen a number of articles, headlines about is whether some of the people who are sentenced to imprisonment or jail time, if they're nonviolent offenders, maybe there should be alternate sentencing.
Mm-hmm.
What is your views on creative sentencing? Tie that in with like the case backlog it concerns, and if you can also wrap that in with the 90% that are settled out of court topic and so forth, tying all those things together if you can, and explain what can be done there.
Sure. Okay, so there's a number of this is a lot longer than 2 minutes, so I'm going to try to get to it all. But there's a number of different factors that contribute to how many cases settle pursuant to a plea bargain or outside of court. And and I'm going to talk about criminal courts, criminal cases, since that's what this court does right now. So the prosecutor makes an offer for a plea bargain, the defendant accepts it or doesn't accept it. And there's not a whole, it's a plea market, not a flea market. There's really not a whole lot of haggling that goes on. Okay? There's a lot of different variables that can be tweaked a little bit, but as far as how that process works, if the district attorney's office and the defendant can't come to an agreement, then the case gets set on the trial docket, and the cases are prioritized based upon the severity of the case, whether the person's incarcerated, and the like. And all of that, by the way, is done pursuant to statute and local rules. Okay? There's only so many cases that can be tried in a week. In Montgomery County, the district clerk is responsible for calling jurors. The district clerk will not call jurors on any day other than Mondays. And there's really nothing that a court can do to force her to call up a jury panel. So as much as it would be wonderful to say, we're going to have jury panels come in Monday, Tuesday, Wednesday, Thursday, Friday, if there's not warm bodies in the pews, you can, hope and wish all you want. It's just not going to happen. Because of the number of felony cases that are filed in Montgomery County, there's no way to try all of them. But one of the reasons why I see that there is a backlog is when one party in some courts believes that if the state believes it's not going to be treated fairly by the court, it's not going to offer plea bargains or agree to try cases to the court, which is much more efficient than jury trials, I might add. It's not going to agree to try cases to the court because it doesn't think it's going to get a fair shake. If the defendant feels that it's going to be treated unfairly by the state and by the court if it goes to a trial by the court, then the defendant is never going to agree to that. But if both parties believe that they'll be treated fairly, we can maximize the efficiency of the court because both parties go, you know what? We can't come to an agreement. I'm willing to take my chances with this person, as opposed to requiring 72 Montgomery County jurors to come in so that we can pick 12 and then have a jury trial. And court trials, if I can just have just a couple more seconds, court trials go a lot faster because a lot of the rules that have to be observed in front of a jury the court is presumed to be only considering what's appropriate, so they move at a much faster clip. So imagine a situation where a jury trial, let's say on an aggravated robbery, might take an entire day to select the jury, and then you have to come back and hear evidence, which might take 2 to 4 days. A court trial, do it in maybe a day and a half.
Okay.
So in that regard, I think that that would be very helpful, is if both parties believe that they'll be treated fairly, maximize the efficiency.
Okay, we have just under 15 minutes left.
Okay.
Good.
All right, so what weight should be given to the law versus judicial precedent? And how much discretion is there for the judge between those?
When the language of the statute is clear, the law applies. There's different levels of judicial precedent that are accorded different levels of authority in judicial decision-making. And so courts are bound by judicial precedent, but there have certainly been situations in which if a court is able to sufficiently articulate why precedent does not apply, and we have situations happen like that in our courts all the time, then sometimes courts can create new precedents. As attorney for the defense, I've been successful in creating an entirely new precedent that now applies statewide in the state of Texas. And so there are times when it's appropriate for a court to strike out on its own and say, in the interest of fairness, and courts, by the way, the Supreme Court has said, and the Court of Criminal Appeals have said, do have an inherent authority to do what is just and right. And so in that regard, I think that obviously the law is the first question and the first answer. But when the law is unclear, we do look to judicial precedent next. And if judicial precedent is unclear or not applicable, then the court has to rest on its own judgment. But most times, even judicial precedent says that it's in the discretion of the court. So as long as the court's decision is not arbitrary and capricious, then the court's decision will be held as appropriate.
So to what extent, if there are existing precedents that are contrary to the law, what then?
Well, it depends on where the precedent conflicts and at what level it conflicts. So there may be for instance, there may be a precedent in, say, the Ninth Circuit that isn't binding in the state of Texas, or there may be a precedent in the Court of Criminal Appeals in Corpus Christi that's not binding in the Ninth Court of Appeals. So it really depends.
Okay. Let's say a defendant claims that he's indigent, and then the court has the responsibility of appointing an attorney for him. I wonder, how do you know that he's indigent or not? And is that even really looked at, or you just take the, who determines?
Indigency, the Office of Indigent Defense.
So.
They have a questionnaire and require that they provide, in some levels, documentation of what they have and, whether
So
they
before
have
they
the
would
ability
go
to order that. Get those
Go to
funds.
trial, they would supply that, and then
Yes.
there would be a determination.
Yes.
And then you come before the judge and say,
And
here's
the
here's
court may
documents.
make an ultimate documentation. So what will sometimes happen is the Office of Indigent Defense will say, no, you're not indigent, and the person will still not be able to afford an attorney. But I think that the important thing is, you're entitled to an attorney. You're not entitled to the most expensive and most outstanding, most famous attorney in town. So, and then what will often happen too is that you might be indigent for purposes of a murder defense, which would likely cost $50,000 to $100,000, but you may not be indigent for hiring an attorney for possession of marijuana, which could cost as little as $250 to hire an attorney. So the severity of the case, the cost of defending a case would also factor into whether I think somebody would be considered
So
indigent.
basically, that group that determines if they're indigent or not, really 99%, if they say he's indigent, you go ahead and appoint an attorney.
The Office of Indigent Defense actually does the appointment.
So the judge has nothing to do with
The
it.
judge has nothing to do with it. And most of the time, the judge will not even know that the attorney is court-appointed until the case is concluded.
Who controls that entity?
The Office of Indigent Defense, the Office of Indigent Defense is controlled by the Board of Judges, but it's within the Office of Court Administration. The head of that is Nate Jensen, and he's a county employee.
Will this be financially a move upward for you?
I don't think so. I'm not sure exactly how much district judges make, but no. That was a big part of the conversation I had with my husband at the time. We've got 2 kids about to be in college.
Okay, so we are about 7 minutes out. Actually, you brought up marijuana. What's your personal opinion on marijuana use? Obviously, it's against the law, but, or at least in most states, but, there are certain states that.
That's a multifaceted question, and part of it comes from my work and what I do, and also the fact that I've got kids, and one of the hard things is I have these young kids that come into my office that get busted for weed, and they're like, well, it's legal in Colorado, and I'm like, thanks a lot, Colorado, because now this kid thinks that there's no big deal about marijuana, and his life is over, because you decided to be a pioneer.
Is there actually a Texas law against it?
Against marijuana?
Yeah.
Yes.
So
Possession of-
specifically, Texas has a law.
Possession of marijuana in the state of Texas in any usable quantity under 2 ounces, which 0.03 grams has been considered to be a usable quantity. And I'll give you kind of an idea of what that means. Take a sugar packet, divide it into 100 different equal sections. 3/100ths of a sugar packet has been considered a usable quantity of marijuana. It's punishable as a Class B misdemeanor, fine of up to $2,000, up to 180 days in jail. And if you're under the age of 21, which is a significant portion of the kids who are caught with marijuana, it's also a year's driver's license suspension. I mean, it stings.
And you're saying that's a state law, not a federal law?
That's a state law. That's a state law. It's a misdemeanor. So I think I understand some of the argument towards decriminalizing minute, very small quantities of marijuana, but from a regulation framework, I don't really have a good idea or understanding of how we can effectively legalize it in the state of Texas. And if, so it's such a 2 minutes, right? It's like, oh, we could talk about this all day. Because at the same time, studies show that marijuana is no more dangerous than cigarettes. It causes less deaths than alcohol, But at the same time, it's dangerous. And kids don't make good choices. People don't make good choices when they're high. I sat today and listened to a portion of a child pornography trial where part of the issue was that the guy would look at kiddie porn when he was high. So it's not just people driving while high. It's not just, there's a lot of different things that can go wrong when people are under the influence. So.
Okay, down to about 5 minutes.
He's already done his.
A couple of
We
times.
skipped him twice.
This is, by the way, this is like the shortest hour or 50 minutes of my life.
He had said
Doing it in
because-
2-minute increments. I'm like, I could talk about this stuff all day. So
Okay, so back to licensing lawyers, doctors. Why is the state better at licensing those people than us as consumers?
I think it's because at that level, you don't know what you don't know. The intricacies of the practice of law and the practice of medicine are so in depth.
But do you want me to trust the government? I mean,
Well,
that there's no
Or
shady?
why is the government better than a lawyer society?
Yes.
well, part of what, a lot of states have a non-mandatory bar, which in Texas we have a mandatory bar, and the Texas Supreme Court is actually responsible for licensing attorneys in the state of Texas. It's not the legislature. That is the Texas Supreme Court, and it's controlled by the State Bar Association, which is an arm of
That's all
the
government
Texas
in my
Supreme
book.
Court.
That's what I
It
can
is,
tell.
it is, but
So I
my,
think his question's a good question.
well, so like if you have what would be called a voluntary bar, which is where,
No, not a voluntary bar where you have a government centralized appointed or whatever. It's where you have a Better Business Bureau group. You have a group that says, we've evaluated these things on their 75 points and this is our ranking. Consumers go do.
and I
these
think that
things.
that's what happens now, is we take a test, and then the top 75% pass, and we're licensed. And by the way, a large portion of the test is also given to attorneys all over the country. So, in that
okay,
regard,
Okay, so you're fighting for it, okay.
in that regard, I mean, do I think that the public is, I think that you would basically have to have a group of lawyers and law professors. The public would appoint a group of lawyers and law professors to determine whether people are competent.
The public.
Right. Who is the public? Who gets to make that decision? So now the Texas Supreme Court makes that decision, and they appoint a group of lawyers and law professors to grade the bar exam
So I
to
want a
determine who
lawyer,
passes.
I want a lawyer, but I want to give this one the government says is not okay. Government doesn't like this guy for whatever reason, government group. Oh, well, okay, so that's, I mean, that's, okay.
But I think you have to look at though, and you have to look at how the bar exam is graded, which it's done completely blind. When we're licensed, they have no idea who we are. It's done completely blind. So, and a portion of it is essay, which is graded by law professors, legal professionals, and attorneys. A portion of it is the multi-state bar exam, which is given nationwide, which is multiple choice. And then a portion of it is short answer. And short answer is you either get it or you don't. You know, you just have to write it out as opposed to multiple choice. So because it's graded blind, I certainly never had any fear that I wouldn't be treated fairly. My concern was just that I was smarter than 25% of the people in the room. Because 75% automatically pass and 25% automatically fail. And in the same way with, I think the greater concern that I would have is like grievances. And I think this happens at the medical board a lot, which is where you have the board decides that they don't like a practicing attorney. And so then they do have a method by which they can go after someone who they have adjudged to be competent based upon not liking their politics, how they handle their business and the like. But at the same time, I've also seen some attorneys do some things that would blow your hair back, that are scary. And they have the ability to have an extraordinarily negative effect on people's lives. So there does have to be some oversight over that based upon the type of work it is as a fiduciary that attorneys have.
Is it 75% pass ratio? Is that a good number? Should it be less, like half, or even less than that?
Oh, I haven't thought of that. I've certainly, one of the challenges is that the bar is not designed to measure competency in any particular area. And so I'll encounter attorneys that you just look at and go, I mean, are you new? You're scaring me here, you know? And then you have attorneys who you just can't believe they passed the bar, but they did. So it's designed to be, it is designed to be a minimum competency exam, and it is up to the public to decide who succeeds and who fails. And lots fail.
So, I mean, so which way are you arguing? You've argued both sides of the case. That's okay.
Well, no, and I think, I mean, it's a good question, and I understand it, but I think that there is, at some level, the type of work that attorneys do is so highly specialized that some government oversight is appropriate. And the government oversight that we have is basically passing a minimum competency exam. And then as long as we don't flagrantly violate the rules of ethics or the law, we get to keep our license. But other than that, it is up to the free market to determine who
So
succeeds and
barbers
who
cut
fails.
people's hair every 2 to 3 months. Lawyers, probably, some people never even go with a lawyer. I mean, the amount of contact, the number of people who safety is affected by, a barber has way more effect than a lawyer, I would argue. So, you know, if it's a safety issue, well, then barbers need to be licensed, not lawyers.
If somebody shears my head bald, my hair will grow back. If someone is completely incompetent and doesn't know and understand the law, and I go to prison for the rest of my life, or I lose the business that I've worked my entire life to build, I lose my family farm.
And if
Or a murderer
they put the
goes-
wrong- And if they put the wrong chemical on your hair or your neck or your fingers, then you'll die in cancer in 3 years. And, you know, you kill a lot more people than you put in jail. But,
And I just respectfully disagree.
okay.
What I want to know is, since when did barbers not have to go to bar? Because we do.
They do.
They have to be licensed by the state.
They do have to be licensed by the state. I just think that if we're going to talk about government oversight and who should be licensed, I mean, there was a bill in the legislature in the last session that the state was arguing that people who braided hair needed to be licensed barbers. That's crazy. No, they don't. They braid things. You know? And if you go to somebody who burns your hair off, but also you're in a position, if you're sitting in a chair and your scalp is burning, you can say, wash it out, wash it out. But when you've got a lawyer sitting next to you and you don't know, you can't say wash it out. All you can do is just sit there and go, they were a lawyer, I figured they knew what they were doing. And so that's my view of it.
Okay. So you got up to 5 minutes to close, unless you want us to.
It's up to y'all. I mean,
It's up to you.
I can close. You've had an opportunity to read about me. Find, you know.
Did you have another question?
Okay,
Now,
yeah.
I saw Dell with his hand up.
He's like, no,
So-
please, let me ask a question. Let me ask a question.
Trying not to interrupt despite.
No. Go ahead.
Okay, question number 14, to what extent do you believe state or federal government, okay, that was the question. But the topic is parents' ability to manage, if you will, bad term, their children.
Mm-hmm.
And you use some terms in there. Throughout your questionnaire, you use the term fairness. I understand, that's probably a fundamental concept, but fairness is one of those gooey things that's hard to really define and get a handle on. It's like jello sticking on a wall.
Mm-hmm.
You use some terms in your answer number 14, talking about where the parents are the ultimate authority as what's best for their children. You have to be convinced of showing abuse or neglect.
Mm-hmm.
Are they truly unfit? Abuse, neglect, unfit. Terms that are very, you ask 10 people, you get 10 different definitions.
Mm-hmm.
So I want to understand what your concept is, whether you think if it's codified in law, do you agree with how it's codified in law, or do you think that those definitions are bad the way they exist in law?
The way that they're codified in the law, neglect is basically considered not providing for the essential needs of the child. Food, clothing, shelter. Okay? The abuse is commonly considered what we all think of as abuse, which is physical abuse, which, by the way, is not considered reasonable discipline. A child under the age of 14, corporal punishment is legal in the state of Texas, okay? And I'm pro corporal punishment. And then, of course, there's sexual abuse, and I think that there are, there's psychological abuse in that type, but it has to be clear and convincing. By the way, clear and convincing evidence is a legal standard, okay? It does have a legal meaning. Clear and convincing evidence that it's detrimental to the health, development, and welfare of the child in that situation. I think that the law says, Troxel versus Granville says, that parents are the decision makers unless there can be clear and convincing evidence, which is the legal standard right underneath beyond a reasonable doubt. So it's a high standard, right? That the child is subject to abuse or neglect. And even then, the law says and courts hold that parents have a right to parent their children, and our courts will go to sometimes what feels like extraordinary means to try to retrain a parent to learn how to be a better parent. So I think that there has been a substantial amount of overreach in our courts with people using CPS and other government agencies to try to step in and exert their will over the will of the parent. But I also think that our courts are in a position where if they follow the law and follow the constitutional principles that were put out in Troxel versus Grenville, much to Justice Scalia's chagrin, that parents are largely left alone to parent. I think there's always extreme cases that we hear about in the news, and those cases really do have to be decided on a case-by-case basis.
So you don't think the free-range parents would ever come up in Texas? That case from out east?
Oh, I can't say what I would specifically do in that type of case. I can say that studies have shown that violent crime has diminished greatly over the last 40 years compared to what it was when I was a child and was allowed to play at the park. I think that there's a significant amount of research being done on how healthy it is to keep our children strapped to our sides all the time and to not allow them any autonomy and the ability to make their own decisions and decide their own, to give them a real sense of agency. And I think that's very important. But as for whether that type of case might come up in Texas, sure, I think it'll come up. And I think it's critically important that we have good judges on the bench who will look at a government agency and say, not this time. Or who will look at a parent and say, I realize that what you're trying to do is the right thing, but here's why it may be harmful. Let's try to put you on a path to doing better. You know, I mean, there's a fact scenario in which any type of decision might be appropriate, but I believe that parents should be the ones to make decisions about what's appropriate for the health and welfare of their children. And that's what the law says, so I'm allowed to say that.
Okay.
So, we have time.
Go ahead.
So under what condition would you side on the case of CPS and say some doctors who diagnose a different condition for a child than the parent and their set of doctors?
I can't say because I think that that is reasonably likely to come up in the court.
Okay.
And I think, in fact, where it comes up in the court a lot, even on the adult side, is where you have a physician who says this medication is medically necessary for a criminal defendant, and the judge says, well, I don't want him to take it. And I think that that issue where we have a judicial ideal or a judicial decision that may conflict with medicine is actually something that comes up in our courts, and so I don't feel comfortable discussing what I would do in those circumstances.
So the logical follow-on to that then is, what do you think of the campaign ethics laws that say you can't comment on something like that?
You know, I think they're really good. And here's why. Because every case is different, you know? And you really can't say, because there's so many different tiny little variables that can be tweaked that would change things entirely.
Well, why can't you talk about one specific case? Doesn't mean you're implying all these other cases are equal. I mean, every case is different, agreed.
Because that's what the
But-
rules say, and I'm going to follow the rules.
Well, no, his question was why, what do you think about the, okay, so, and I agree with that, you are a rule follower. I have concluded you are a rule follower.
I'm going to follow the rules.
Okay.
But yeah, I understand your frustration. And I would certainly love to sit here and say, oh my gosh, and let me just tell you that if anybody came into my court and this happened, this is exactly how I would handle it. But you know what would happen under those circumstances? One of the parties would file a motion to recuse, and all of you would be paying for a visiting judge to come in and do my job.
I understand.
All right, that sums it up. We appreciate you coming in
No,
tonight.
thank you guys for having me, like the shortest
And,
hour ever.